Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us today. Joining me as my co-host, Jesse Barrantes. Jesse, welcome to the show.
Thanks, Dave.
Jesse, we're going to be talking about some family law issues that we received from our viewers, some questions,
Okay.
A wide range of issues, which is great, that I'm going to hit you up for your best answers. I know you can't give legal advice per se, but you can give generalizations on what these people could be looking for if they wound up going forward with their issue,
Can
correct?
give you an idea, sure.
Okay, let's start it out with Kevin. He's from Stager. A little background on Kevin, Jesse. He's got 2 children, a 6-year-old and a 9-year-old. Okay, he's got a boy and a girl. He works as a medical tech. He earns approximately $60,000 per year. His wife is educated but refuses to work. She may be bipolar. He's not sure, and she's got some other psychotic issues, he believes. She refuses to seek treatment. He would like her to seek treatment, obviously. The question is, the marriage is dissolving. They're not getting along. All these issues that she has are causing a problem with their relationship. He's concerned about his children, too. So with that background in mind, he asks, he's considering fighting for custody. What is the best interest of the child standard, and what are his odds?
Well, first, I think we need to back up a little bit. What I always recommend to everybody that comes in is, hey, look, is the marriage dead? Is it really dead? If not, what needs to happen is they need to go in counseling and to try to, to really save that marriage. If there's an issue and there's a problem with what's going on with the situation and the children, then counseling is always an option. You know, a lot of people like to talk the talk a lot. Oh, I'll do whatever is important for my child, but when something becomes inconvenient, then, a lot of times they don't do that. But I will tell you, the standard is what's the best interest of the child. What's going to happen? And, she's educated, she doesn't work. I mean, I wish I had some more facts, but we have what we have here.
Yeah.
I don't know when she had worked last. I don't know whether or not that she got her education during the course of the marriage, whether or not, they paid for her education during the course of marriage, whether or not there's any student loans owing or anything.
I can fill in a couple details for you. She's a college graduate,
Yep.
but she didn't work during the marriage. They started a family right away, and she's been a stay-at-home mom.
And how long have they been married?
About 11 years.
About 11 years, okay.
Yeah.
So, you still have an issue because, look, here's somebody, even though she has a college degree, hasn't been in the job market. And so probably what's going to happen is that, she's going to need to get some training. And, I mean, that's the only fair thing. Remember, a divorce is an equitable division of assets and of liabilities and all that stuff. The court tries to do what they believe is fair and what's equitable among everything else. In terms of custody, now...
He's worried about his kids, remember now.
Well, he's worried about his kids.
She's got some potential mental illness issues that she will not seek treatment for, and it's starting to show some effect on the children. So that's his concern. He really doesn't want to strip the wife from her obligations and her ability to raise the children.
Right.
But it's a health issue now that he's concerned about. And will the court buy that, or will he just be denied?
Well, I hear that all the time. Oh, he's evil. Oh, she's evil. Oh, he did this, she did that. And, he drinks too much, she smokes too much, somebody drinks too much Starbucks. I mean, it could go on and on. Just because somebody has an infirmary like bipolar doesn't necessarily exclude them as being a custodial parent. What's going to happen is if there's a custody battle, it's going to end up costing them a ton of money, because what's going to happen is First, the court is going to send them to mediation. A mediator is an attorney, doesn't have to be an attorney, but someone who's had the appropriate training, generally they're attorneys, and he or she is going to try to help the parties reach an agreement as it relates to custody and or parenting time or visitation. We like to neutralize it instead of visitation. I mean, parenting time is really what it is. And sometimes that will be not successful, sometimes it'll be successful, sometimes it'll be partly successful. So after that, assuming that it's not successful, what's going to happen is that the court is going to appoint a guardian ad litem, which is an attorney who has specific training, and that person is going to go out and do an investigation and report back to the court on what he or she believes is in the best interest of the child.
And this is an independent third party that does not have any relationship whatsoever with the parties or the children?
That's
at all?
correct. And there's three things. There's a attorney for the child, there's a child rep, and there's a guardian ad litem. Guardian ad litem really represents the children, but it's not the children's attorney. So that person, regardless of what the child or children may want, depending upon their age, they're not bound by what it is. They're bound by what they believe in the situation, and based upon their investigation, what they think is in the best interest. Child rep is a little bit different. It's a combination of guardian ad litem. Guardian ad litem will write a report. Guardian ad litem can be questioned at the trial. Cannot necessarily participate in terms of filing motions or anything like that. Child rep can do all those things, and except that person doesn't get questioned, doesn't write a report. A attorney for the child is just like an attorney for anybody else. Their children are their clients, and they're kind of bound by that. And so, generally, though, some places, like in Will County, they'll appoint a child rep, DuPage, guardian ad litem, and that's kind of what it comes down to.
What could Kevin expect from this investigation? Because for a lot of people, that's pretty scary. The children are going to be questioned, correct? And
Right.
That's not something you really want to drag your children through.
The guardian ad litem is going to look at the situation, is going to look at whatever records. If the person has been diagnosed as bipolar and she's been to an institution or whatever, is going to look at those records and is going to base their investigation upon that. They're also going to look at, hey, look, he's a medical tech. He's working all the time. So she's not working. She's at home. And unfortunately, I hate to say it again, there's no guarantee about it. However, when you look at something like that and, where the kids are going to go, that's something you really have to take in consideration. When you have a situation where both parties are working, that kind of takes that issue out of the equation. But again, you really don't know. One thing I also want to tell you, too, for him is that a 604B child psychologist or evaluator, custody evaluator, can be appointed. Now, that person is a psychologist and is going to interview the parties, is going to interview the children, anybody else that you think. They're going to do a wide-ranging job. They're going to talk to any therapists, anybody else, and they're going to make a determination or write a report based upon what they think is in the best interest. That will set you back, $8 to $10 grand, and that's just for the report. And then the other party, if they're not satisfied, can retain a 604.5 expert, which is their expert, does the same thing, and it costs about the same. Then you have a battle of the experts. That's why I'm telling you, it's going to cost a lot of money that could go for those children's education.
Yeah, it also sounds like you have a lot of different players involved in this situation, whereas if the parties can just somehow go to counseling or mediate it on their own, without the custody experts,
Right.
without the court-appointed experts, they might be better off in the long run.
I think that's definitely the case. I'm a firm believer, look, you have control over what's going to happen. Once you turn it over to the judge who's going to make a decision based upon a thumbnail sketch of your life, because they have a whole bunch of cases, they're only going to be able to hear the information that's presented to him or her during the course of the trial. And they're going to make a decision, and both parties aren't going to like it. Of course, one party is going to like it maybe a little bit more than the other one, but it's going to cost a ton of money because of the duration of the trial, depending upon what experts you have. Sometimes you even have a 604B expert, 604.5, and a guardian ad litem or a child rep. And guess who's paying for these people? It's the parties.
Right. Okay, that's good advice for Kevin and Stager. Next question comes from Terry in Joliet. You mentioned Joliet earlier. Let me give you a little background here. They're divorced 4 years, so you've got a post-decree situation here. Child is now 10 years old. The judgment calls for alternating weekend visitation. So they're going to alternate every weekend. Someone gets the child for visitation. It has not been consistent. Husband has struggled with alcoholism. So you have another issue here causing a problem in the family relationship. Wife then refuses the visitation consistently because he's not capable due to the alcoholism. He accepts his weakness, the husband does, ex-husband, and he's taken some corrective action. So he's gone to some treatment and some counseling to try and better himself through AA. He wants to get back on the schedule that was in the original divorce decree that they abandoned because of his issues, and he wants to know How can he get back on that schedule? Because his ex-wife is making it difficult now. She's not allowing the visitation, still believing that he has these issues, and she's concerned, obviously, for her child, who's now 10.
Well, I can tell you extrajudicial agreements, which means an agreement that changes what a court order has set in place, is really not valid. It's something the court certainly can consider. The way that a party enforces a court order, whether or not it's visitation or whether or not it's child support. Say, for example, you're supposed to pay $100 a month and you haven't paid it. Okay, so you got to force the person. You file what they call a petition for rule to show cause. If it is done and it is a verified petition, then depending upon which county you're in, because the counties are different, the court will enter a rule order requiring the other person to show cause why they shouldn't be held in contempt of court for failing to obey whatever court order that is. Now, this is very important. Whoever files a motion generally has the burden by a preponderance to prove whatever it is they're alleging. But when you do a petition for rule and the rule order issues, the burden shifts to the other person. And then if the other person can overcome it, then it shifts back to the person who filed it to be able to rebut what's going on. So
we could have multiple hearings regarding this issue of visitation,
it should just,
even though there's already a court order in place from the divorce decree stating alternating weekends.
It should just be one. You know, what probably would happen, and again, in a general sense, is we'd file a petition for rule and to hold her in contempt for not following there, because from what I've heard you, the order is still in place. It hasn't been modified.
Correct.
All right. So then they're going to hearing, and then the burden's going to be upon her to show that it wasn't willful, and she's probably going to argue that, hey, look, he has been intoxicated, I've smelled out, whatever she's going to say. But I'm guessing that there's been multiple violations of that order, because if the order generally calls for every other weekend, alternating holidays, and it hasn't happened for a period of time, there's multiple violations. And then the court's going to have to look at that and try to make that determination.
Well, there was a time here where he was not exercising the visitation due to his issues.
Unfortunately, you can't force somebody to exercise. I hear that. I get that too. The one of the spouses says, "Well, the other they're ordered to do this and they're not." And, well, unfortunately, and it's a sad day for the children too, because they really need both spouses in their life. But you can't force somebody to do that. But he hasn't done it. That's okay. That's going to be a consideration. But the bottom line is that if somebody has willfully violated a court order, there's going to be some penalties, and those penalties can extend anywhere from attorney's fees to even some jail time.
Well, I think the ex-wife is counting on the court taking into consideration the fact that the safety of leaving the child go with the ex-husband in his condition or purported condition. Obviously, she's not conducting a sobriety test on the spot. He's not blowing into a breathalyzer, but there's been issues in the past. So I think the court, she's banking on the court thinking that, oh, she's protecting her child.
Well, but the burden's going to be upon her for that. I mean, she's probably should file a motion to modify visitation.
Okay, a delicate issue here, but I think in this case, from what I know about it, the judge is probably going to want to have an in-camera interview with the child, because the child is going to testify, or at least advise the judge, that on certain visitation outings, father has imbibed.
That, an in-camera interview of the child, which is just the judge talks to the child in chambers, it is recorded. Both attorneys can be present unless that's waived. However, what is probably more likely in that situation is that, again, it's like we talked in the last example, the court's going to appoint a guardian ad litem.
Even on this issue?
Or a child rep.
Even on this post-decree issue?
Not for a petition for rule, because the petition for rule just says, look, show cause why you shouldn't be held in contempt, and that's up to her. However, if she were to file a motion to modify the visitation time, then that's where that would come into play. But the court has broad discretion, and they could do that. The truth is that we have different judges that have different personalities and different thoughts and different issues, different takes on all these issues. And so realistically, you could have the same issue in front of 3 different judges and get 3 different results.
And in some counties, the judge who originally heard your divorce doesn't hear the post-decree issues in some counties.
In some counties, but I believe in Joliet it will be, it should be the same judge. Now, of course, if somebody retires or moves to a different division, that's a difference.
Well, I know Cook County has it broken down into an alphabetical calendar as well as a numerical calendar. And that alphabetical calendar, you're going to get a different judge than who heard your underlying cause. So it really depends. And that judge...
It's a game changer.
Yeah, the judge doesn't have a history in the case, doesn't know all the issues that took place pre-decree. So something to consider. Can you talk about supervised visitation, as long as we're in this issue here? Is there an opportunity for supervised visitation by the fact that he's rehabilitating himself, and can you explain to the viewers what that is?
Well, if that were a factor, and again, we're just talking about a rule to show cause, so that just, unless she were to file the appropriate motion, that's not really going to come into play. Although supervised visitation, and they have, in DuPage County, they've got their family services where you set up a time and it's done under the supervision of the staff and everything else. It could be supervised by a third party. It could be supervised by there are other places that you can pay for them to supervise. It could be supervised by a grandma or grandpa. And, when you get into stuff like that, one person doesn't want to go and be supervised by his in-laws. Okay,
Right.
Doesn't want to be supervised by his ex. However, I could see that a guardian ad litem may, or even a judge may, want to recommend that, hey, look, the child reestablish a bond, or the parent reestablish a bond with the child, so that you have that connection. If you come in and somebody hasn't seen the child for 5 or 6 years, hey, there needs to be something set up. And again, everything is based upon the best interest of the child.
Okay, let's move along to a pension issue. This comes from Laura in Chicago, and let me set up her situation. She's seeking dollars from her husband.
Okay.
She's seeking money. That's what she's looking for in this case. She's being totally honest about that. She's married to a Chicago police officer who's nearing retirement. He worked on homicide cases for 10 years. He fought against the gangs and the violence during the past 3 years. However, he has not yet faced an adversary quite like his soon-to-be ex, his wife. She wants blood, Jesse. This is what she stated. Because he has had a girlfriend. You see, there's always somebody's done something wrong here. And a very young girlfriend at that, 28 years old. Okay? She knows that he has a huge pension with the city. She's been married to him for 29 years. Sorry, with him for 29 years. Only married, this is key, for the last 6. So they lived and they lived together for a long time without being married. They're only married for the last 6, even though they've been together for 29 years. She wants to know what she could be looking at. And remember, she wants as much as she can get. She's angry.
Well, I can tell you, and I've had people that come into the office and they want blood. It's not much about dividing everything up and all that. They just want blood. I tell them there are plenty of other attorneys out there that'll do that for them and take their money. I'm not one of those.
Right.
I just want to get the job done. I want to make sure that it's equitable and we resolve it so everybody can move on with their life. So that's how I approach that.
Right.
However, I will tell you that if she wants blood, she's going to have to watch Shark Week, because we are here in July. Because if they've only been married for 6 years, she's only entitled to the marital portion of the pension, which is for that 6-year period. Now, does she work? Does she have a pension?
No.
Okay, so
He was taking care of her.
we don't have to
They were
worry about
relying
that.
on his income.
Right.
They were taking vacations. He did buy her gifts. They had a pretty extravagant lifestyle. He made a decent living with the
Chicago
CPD.
cop?
Yeah,
Sure it wasn't narcotics?
I'm sure it was
Okay.
not narcotics.
All right.
And keep in mind, she feels that the 23 years together that they were not married has value as well.
Well, if you were in California, maybe, but you're not in California, okay? You're here in Illinois, and it's not gonna happen. It's just gonna be that little snapshot of your pension and the marital portion. More than likely, the court probably would do 50%. I mean, they could give a higher share of that, but if he's been working for 20 years, we're just looking at a little bit. And, there's actuaries that, kind of determine on, okay, look here, when was the course of the marriage, what is this portion, and everything else. So that's kind of what you're looking at.
Well, let's say we have a protracted divorce case. All that time they're still married.
Yes,
She's entitled to that time period.
that's correct.
Okay, and he can't stop that because it's a pension. He has to, it's part of his income.
That's
So if she drags the divorce out for 2 years, she's going to pick up an additional 50% of those 2 years, in your opinion?
that's what's going to happen.
Yeah. He might want a quick divorce. He might be moving on. He has a girlfriend. He's going to see that she's out for half of whatever
I don't know
she
that
can
he
get.
would be that quick to, but hey, stranger things have happened. But the bottom line for her is, however, she might get maintenance. There were no minor children, right?
No.
Okay.
I think the real issue here, and for our viewers, is what is marital property?
Yeah.
And how is that determined?
Generally, marital property is anything acquired during the course of the marriage, and that includes marital debt as well. There are some exceptions. Exceptions certainly is going to be, let's say, Uncle Harry left you an inheritance of $1 million, and you didn't put that in the joint names of the parties, then that's yours. Okay. If you had a house,
What if you put it in a property in both names?
well, if you put the property in both names, then it's what they call a fancy term. It's transmuted into marital property. I mean, you could try to prove and try to trace it, but basically, if you put it into both names, it more than likely is going to be considered a gift. If, however, let's say you have your marital property, that a house that you had before you got married, now you get married. Well, it's non-marital. However, there is what they call a right of reimbursement that's going to go to the marital estate. And when two get married, it becomes one. And so, again, here's the money that's been paid to this non-marital property to pay for the mortgage, to pay for the taxes, to pay for any repairs. And so, whatever that amount is, there's a right of reimbursement. So, and you have to prove this, of course. Let's just say, and make it easy, okay, during the time, spent $100,000 in improvements and taxes and paying the mortgage and all that stuff. Okay, so what? If we're looking at 50-50, then we're looking at $50,000 that is gonna, more than likely go back to her. And again, it depends upon what judge you get and what their thought process is on that subject.
Okay. Let's move on to Darian in Lamont. Darian is a seasonal worker. He is hurt by the current economic situation, so he's not making as much as he used to. He can't find a higher full-time job, which is why he's stuck in this seasonal job. He wants to continue in his current divorce case. He does have a lawyer right now, but he's not making his ends meet, and he's not able to really pay his attorney's fee. So the attorney is threatening to withdraw because he can't pay the attorney's fee. And he wants to know what he can do in this situation to try and convince that attorney to stay on the case.
Well, Dave, let me give you my experience here. Okay. If you can't pay a balance of, I'm just picking a number out of the air, of $500, and you're continuing on with the divorce, and it's going up to $1,000 or $2,000 or $3,000, then it's not going to happen. More than likely, what's going to happen, and my experience has been that, hey, after you do the work and the dance is done, oh, gee, people don't want to pay you anymore because you've already done the work. A judge, and he's deceased, is Judge Gerald Bender from Cook County. I went to school with his, I think we both did, with his son, Mike Bender, who was a judge and now in private practice, told me one time that if you don't get paid, you're doing your family a disservice, which is true. People go to work, they expect to get their paycheck, and it is really no difference for an attorney. Now, some attorneys might extend you a little bit more credit and some won't, but there comes a point which is too far beyond any kind of recompense. It's not going to happen. And so now I'm working for nothing. That wasn't our deal. If I agree to do something for nothing and I agree to represent you without getting paid, that's one thing. However, I still have the option of withdrawing. But if I didn't do that and we made an agreement and you're not living up to your end of the agreement, it's sad to say,
Okay.
You know, it's fair enough. Or,
What's the process that Darren should be looking for here in terms of the attorney withdrawing?
well, the
Is it just
attorney,
a-
right? The attorney will file a motion for leave to withdraw as his attorney, and it'll be motioned up, and it has to be served either personally or by certified mail, and there'll be a hearing date, and then the judge,
Can Darren object to it based on the
Darren-
information
he-
I've just told you and relayed to you?
he can object to it, and different judges are different. If a trial date has been set, depending upon which county you're in, some judges might not let the attorney out, which means now, and
Even though the attorney's not being paid?
even though the attorney's not being paid. I disagree with that. I mean, I understand where that's going because you don't want to delay, but you know, involuntary servitude was long abolished in the state and in this country. Okay, and so I will tell you though, do you really want an attorney who's not getting paid to represent you? What do you think that attorney may or may not be doing?
Right. Well, ethically, the attorney would have to be zealously representing the client, but
Well, I mean,
it's a risk, I
True.
would say, to have an attorney that you're not
True.
paying represent you in a divorce case.
right, and it just depends on where you're at and what the stage of the game is, and where you're at. So.
Okay. Just a couple minutes left, Jesse. Let's
okay.
move on to Camilla in Riverdale. She wants 50% of the marital estate. She wants to make sure that she doesn't lose out on what she's entitled to, and the parties have a home, 28-year marriage, 4 grown kids, and approximately $150,000 worth of assets combined.
Okay.
That's what she's looking for.
Is she working?
No.
Nobody in any of these call-ins are working. My goodness.
Hey.
I
The people who are working can get by on their own. These are people who are in bad shape.
okay. So
Real quick, we don't have a lot of
well,
time.
real quickly. I mean, 50% sounds reasonable to me for that duration of the marriage. And again, she's most likely going to be entitled to maintenance. You said they were emancipated children, right?
Yes, 4 grown kids.
Yeah, so child support's not an issue. If they're grown beyond the college age, then we don't have to worry about contribution to college expenses. So really, what we're looking at is, I mean, I think that's that's a nice division of everything.
There is some artwork and things that have to be appraised, so it's not a simple,
Right.
We'll just divide the bank accounts. There's some issues here, but obviously she wants to have everything reviewed, get her own market evaluation of the home and things of that nature.
If she's gonna, or if he's gonna buy her out, or if she's gonna buy him out. Generally, you have a situation where if the wife is gonna buy the husband out, she wants the property to be at a lower value. If it's the other way, the husband obviously wants to be a higher value if she's gonna buy him out. If, however, they're both gonna sell the home, then both parties have an interest to try to get as much as they can out of the property. So you have to look at what the situation is.
Okay, so again, just to review, we've covered marital property,
Yep.
we've covered pension, we've covered custody, visitation, rule to show cause. We've covered a pretty wide range of issues that come up in a divorce case. But I think the best advice is what you started off with. If the parties can save the marriage, that's the best. If they can't, if they can work out an agreement amongst themselves, have the attorneys prepare it, have it duly reviewed, that's the next best option. And then the least option is to litigate, correct?
So that's absolutely right, and really need to go and talk to somebody who is familiar not only with this area of law, okay, because it covers a bunch of stuff family law does, but also someone who's familiar with the local judges that you're going to be in front of, so they know what the nuances are.
Okay. Jesse, thanks for joining me again.
Thank
Great
you, Dave.
information, great advice. We'll see you next time on Legal Action. Take care.
Yep.